Hey folks, good day. My name is Greg McLawsen. I'm the Affidavit of Support lawyer. I represent plaintiffs in lawsuits in federal court to enforce the Affidavit of Support, and I serve as a consulting expert in family law cases when the Affidavit of Support is enforced in a divorce case. Today, I wanted to talk about how parties generally approach settlement agreements in Affidavit of Support cases. And I think the most important thing to start off by mentioning is that settlement should be your goal, either as an affidavit of support plaintiff, but also if you're an affidavit of support sponsor. Why? Because nobody gains anything by proceeding to litigation in these matters if they can possibly help it. Going to court is the last option if settlement fails. That's true as a defendant because you don't want to be spending money if you don't have to. Remember that affidavit of support sponsors are liable for both their own attorney fees and also for paying attorney fees and costs for the plaintiff. But also as a plaintiff, sometimes my clients tell me that they don't want to settle and they want to enforce the affidavit as if those are two different things. But that's not how legal claims work in the United States. Going to court is what you do if you can't get the other side to voluntarily agree to what you want. What you ideally want as a plaintiff is for the defense to agree that they are liable under the affidavit and to reach a fair payment agreement. That's the goal. So let's drill down a little bit and talk about what a settlement agreement might look like in an affidavit of support case. I'll mention too that statistically, most affidavit of support claims do eventually result in settlement. I have other videos about how long that typically takes. Often cases settle not right out of the gate, but typically after litigation commences, after the defendant has an opportunity to educate themselves about the case law about the affidavit of support. Typically relatively early in the litigation process is when you'll see these claims voluntarily resolve. When it comes to structuring a settlement agreement for an affidavit of support case, typically I think about the finances falling into three different buckets. So remember that the core right of an affidavit of support plaintiff, that is the sponsored green card holder, is to have support equal to 125% of the federal poverty guideline. For a household of one in the year 2022, that's equal to $1,400 per month approximately. Vanessa. Muchísimas gracias. ¿Dónde está?
En la silla, los zapatos.
My cleaners found my truck keys. That's awesome. Okay, back to affidavit of support litigation. The core obligation of the affidavit of support sponsor is to ensure that the sponsored immigrant has income at or above 125% of the federal poverty guideline, $1,400 per month. So the calculation of damages is theoretically straightforward. The obligation of the affidavit sponsor commences when the sponsored immigrant becomes a green card holder, and it terminates only upon one of the 5 terminating events set forth in the affidavit. Again, we have other videos on that. But basically, it's pretty easy to calculate the damages that are owed because all you have to do is look over the time period commencing when the U.S. resident, the green card holder, got their green card, bring that up to the current date. And damages are equal to the difference between the person's actual income and $1,400 per month. I'm using the 2021 guidelines, but you get the picture. So right now it's April in 2022. So if you had 4 years of 4 years with zero income, sorry, 4 months with zero income, that's 4 times 1,400, and there you have your damages. So any settlement agreement for the affidavit of support is first of all going to include an allocation for what's owed up to the date the settlement is reached. And that's basically just a matter of arithmetic, the difference between the person's income and 125% of the federal poverty guideline. Now you're going to get into arguments about what does and doesn't qualify as income under the Flores decision, which we litigated here in Washington State, Federal District Court in Seattle. Income refers to the immigrant's taxable income. But defendants typically want to poke around and figure out if they believe the immigrant is working under the table, et cetera, et cetera. So these are factual questions that you get into in the settlement process. And usually there's an exchange of documents to try to demonstrate what the green card holder's actual income has been. So that's number one. The first bucket of settlement funds is calculated in terms of the support. I call them the support arrearages, the claims that have accrued up to the date where settlement is reached. Number two is a valuation of future claims under the affidavit of support. Because the affidavit of support obligation, the financial obligation of the I-864 sponsor, carries on indefinitely into the future. It terminates only on one of the 5 terminating events in the affidavit. You can read our blog post on that topic. But the 2 primary ones are that the sponsored immigrant becomes a citizen or has 40 quarters of work. 10 years does not terminate the sponsor's obligation. That's a common misconception. People will say that the affidavit of support terminates after 10 years, but that is not true. It terminates after 40 quarters of work. But you can see that to take that scenario I just mentioned, where the person has 4 months where they've been unemployed and they're seeking recovery for that. That's a relatively small amount of money. But if that sponsored immigrant is still unemployed, they have significant financial value associated with the future claims that they have under the affidavit. So if that individual is unemployed, doesn't have clear prospects of employment, when we're looking at the value of what it's fair for that individual to recover under the affidavit, it's not 4 months of support because the person has been unemployed for 4 months. Instead, that person is likely going to be entitled to ongoing support for a period of months or years. Now, one way to approach that is simply to have the defense agree that payments will be made indefinitely to the beneficiary until one of the 5 terminating events occurs. So the parties can simply agree that the defense will check in with the plaintiff every month, see what that individual's income has been, and the sponsor will cut a check equal to the difference between what the person earned and 125% of the poverty guideline. Now, that is completely fair in one sense, because the plaintiff isn't going to get more than she's owed. The defense isn't going to pay more than the defense has to pay. However, there's quite a lot of administrative oversight associated with that. You're going to have to, as the defense, check in every month and spend time sussing out what the individual's income is. Maybe you end up in a dispute over what does and doesn't qualify as income. So this just drags out potentially for quite a long time, how long the parties are going to be in touch, potentially fighting over the claim under the affidavit. What we see more often is that both parties prefer to simply reach an agreement about the future value of claims and associate a single number with that. So instead of saying that we are going to spend potentially the rest of our lives checking in every month about this affidavit of support issue, the parties will simply say, look, we think that this individual is going to be out of the workforce for a given period of time. We will do our best to come up with a fair number that we can both live with. Let's just say in the case of this individual who's been unemployed, it's $50,000. So we will put $50,000 on the table, and in exchange, the I-864 plaintiff will bargain away all of the future value of their claims under the affidavit. Now, both parties assume some risk under this approach. The defense has some risk because they might end up paying more support than they would had they agreed to check in on a monthly basis. But the same is true for the plaintiff. The plaintiff might end up with less. If that individual is unemployed for several years she might end up in a situation where she's getting less through that lump sum settlement than she otherwise would be able to. And that's a risk that both parties have to take in the interest of reaching a settlement figure that they feel like they can both live with. And then they have the advantage of just clean settlement, everybody walks away, and the matter is resolved. So that's how in the real world most of these claims end up getting resolved, is that we have a specific number associated with the valuation of future claims. So bucket number one is support owed up to the date of settlement, what I call support arrearages. Number two is evaluation of the future claims. And then number three is the final thing we'll talk about, which is attorney fees and costs. So under the Affidavit of Support statute, this is 1183 A sub C, the sponsored immigrant has a statutory right to recover the costs, including attorney fees, of enforcing the affidavit. And this can be a big one. So people often say that they understand litigation is expensive. Let me just throw out some numbers to give you an idea of how expensive. So the lowest attorney fees that I've seen assigned to one of these cases, which was resolved very early on in the default stage. So the defendants didn't even show up and defend the case, but there was some back and forth in the litigation, was about $20,000. So these cases often involve only a few $1,000s of support arrearages. The claims can be relatively modest. But if the defense puts down their foot and says, we are not going to settle this, come and get us in court, that's an expensive proposition. But where a party refuses to settle, that's really the only option a plaintiff has, is to hold that person to account in court. So you end up in a situation which is common in cases like Fair Labor Standard Act claims. Those have the same situation, where attorney fees will often greatly exceed the amount of damages that are at stake in the case. And that's why Congress probably included an attorney fee provision, because Congress understood that a plaintiff would never be able to enforce this affidavit in the open market unless there was an attorney fee provision. Because if that plaintiff were paying their own fees, well, it would never make sense to spend $20,000 to enforce a damages claim where arrears are worth $4,000 or $5,000, right? So in order to make the Affidavit of Support rights a real thing, Congress gave the plaintiff the entitlement to recover fees and costs if they have to litigate it. This has the salutary, the good effect of incentivizing both parties to come to the table early in the litigation process when fees are very low and reach a fair settlement. This is, again, one of the reasons that settlement is a very smart option for the I-864 sponsors of the world. Because if you can come to the table and reach a fair valuation of these claims before a complaint is filed and before all of this time is spent on the procedural minutia of a lawsuit, you can save thousands and thousands and thousands of dollars and spend that money on a settlement that goes to the support of the beneficiary rather than spending it on two teams of lawyers litigating these claims in federal court. So again, everybody's better off if the thing settles before serious litigation is required. So bottom line, the main approach to these matters in terms of settlements is there are three financial buckets. Number one, support arrearages that are due up to the date of settlement. This is simple arithmetic, which is 125% of the poverty guideline minus whatever the sponsored immigrant has been earning. Number two is future support, so a valuation of the claims that the parties think the plaintiff will be entitled to in the future. That is an inherently uncertain calculation, but that is both parties doing their best to come up with a fair valuation for what those future I-864 claims are worth, so that both parties can simply reach a specific figure that they can both live with and walk away from the matter with it fully resolved. And then finally, there's a cost and attorney fee allocation in the settlement agreement because the plaintiff is statutorily entitled to costs and fees. And the sooner in the litigation process that settles, ideally before litigation, the lower that final number is going to be, and the better off the sponsor is going to be. Probably the happier the plaintiff is going to be, because more funds from the settlement agreement can go towards paying the costs that's entitled that the defense needs to pay to the sponsor. The defense needs to pay to the sponsored immigrant. So settle early, let everybody go on their way. That is the happiest resolution of these cases in the real world. If you have specific questions about cases, feel free to contact us on our website. We offer free case assessments everywhere in the United States. If you have generalized questions about approaching settlement, you're welcome to drop it into the comments or on the blog post, and we'll be happy to respond there. Take care, everybody.